Have the Deputy de St. Albert, Edmonton.
Thank you, Madam Speaker. It's an honor to speak to Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP. The purpose of this legislation is to align Canadian laws with UNDRIP. Now, Madam Speaker, the road to reconciliation has been a long and difficult one with many ups and downs. And underlying it all is an understandable level of distrust on the part of Indigenous peoples. And seen in that context, arguably it could be said at best that this is a well-intentioned piece of legislation. But even if that were so, Madam Speaker, it does not make it a good piece of legislation. Madam Speaker, indeed, this legislation will likely move the process of reconciliation backwards rather than forwards and have grave impacts upon First Nations communities to develop and prosper and achieve true self-determination. Madam Speaker, this legislation in that regard would undermine reconciliation. And nowhere is that clearer than in the complete failure on the part of this government in this bill to define what constitutes free, prior, and informed consent. Madam Speaker, what is free, prior, and informed consent? If one were to look at the words of the Minister of Justice, they would be led to believe that it really means not much of anything, that the status quo ante would not be upended. In that regard, the minister, when he spoke in this House on this bill on the question of free, prior, and informed consent, said, quote, "Free, prior, and informed consent does not constitute a veto power over the government's decision-making process," closed quote. The minister went on to say that, quote, "It will not change Canada's existing duty to consult with Indigenous peoples," closed quote. Well, Madam Speaker, clearly that cannot be so. Free, prior, and informed consent is not the same as the duty to consult and accommodate that is embedded in Section 35 of our Constitution, in which there is a wide body of jurisprudence on that doctrine that makes clear that the right to be consulted and the right to be accommodated does not constitute a right of an absolute veto. Madam Speaker, when one looks at the words free, prior, and informed consent on their face, it would seem that that would mean precisely the opposite of what the minister purports, namely that there would be a veto by someone. Madam Speaker, consistent with that, many persons who are authoritative on this matter have said as much. Take Senator Murray Sinclair, for example. Senator Sinclair championed Bill C-262 in the Senate in the last Parliament, which was the predecessor to this piece of legislation. Of course, Senator Sinclair is an esteemed retired justice of the Manitoba Queen's Bench. On the question of what constitutes free, prior, and informed consent, Senator Sinclair said this, quote, "Free, prior, and informed consent is a very simple concept, and that is, before you affect my land, you need to talk to me, and you need to have my permission," close quote. You need to have my permission. Madam Speaker, if that isn't a veto, I don't know what is. Then there is Assembly of First Nations Chief Perry Bellegarde, who said on the question of free, prior, and informed consent, quote, "Very simply, it is the right to say yes and the right to say no," close quote. The right to say no, full stop. If that doesn't constitute a veto, then again, I say I don't know what is. Now, Madam Speaker, it didn't have to be this way. One thing the government could have done was incorporated language expressly into the bill that made clear that free, prior, and informed consent does not constitute a veto. They could have provided a clear definition of its meaning and its effect, thereby removing the considerable questions that currently exist about the implications of its meaning and effect and what that will do to the development of major resource and other projects if this bill is passed. One thing that is certain in the face of the lack of a definition is that this will create considerable uncertainty and a torrent of new litigation around major development projects, undermining regulatory certainty, undermining investor confidence, and undermining the ability of individual First Nations communities to determine their own destiny by seeking opportunities to engage in projects and see projects and participate in projects that can help their peoples develop and prosper. Madam Speaker, this is hardly a hypothetical. One need only look at Bill 41 passed by the BC NDP government in December of 2019. That bill is quite similar to Bill C-15. It does not expressly enshrine into law UNDRIP in the province of British Columbia, but it uses aspirational language about aligning BC's laws with UNDRIP, similar to Bill C-15. Within 2 months of the passage of Bill 41, 3 major projects were challenged, including the Kitimat LNG project, the Site C Dam, and Coastal GasLink by the United Nations Committee on the Elimination of Racial Discrimination. The UN committee said that UNDRIP does apply and that there had not been free, prior, and informed consent. And many Indigenous communities and leaders also took that position. And Madam Speaker, that was despite the fact that in the case of the Coastal GasLink, 20 Indigenous communities had supported the project, but one faction of the unelected hereditary chiefs opposed the project. It underscores, Madam Speaker, that the uncertainty that will result in the passage of this bill, and it is why I cannot support this bill. Thank you, Madam Speaker.